Good afternoon and welcome to the Public Service Commission. We are here today for oral arguments in docket 2021-114E. Before we get started, let's take a roll call of commissioners. In the hearing room, we have Commissioner Powers, Commissioner Caston, Commissioner Thomas, Commissioner Williams. Virtually we have Commissioner Belser, and virtually we have Commissioner Irvin. Mr. Butler, I'm going to ask you to read the docket, please.
Yes, Madam Vice Chair and members of the Commission. This is docket number 2021-114E. It's a petition for declaratory order by Orangeburg County Solar Project, LLC, and Orangeburg South Solar Project, LLC. And they're asking the Commission to determine the applicability or lack of applicability of Section 5833-20, which is a portion of the South Carolina Utility Facility Siting and Environmental Protection Act. A virtual oral argument has been scheduled for today, October 20, 2021 at 2 p.m. And Madam Vice Chair and other members of the Commission, the docket is in order.
Thank you, Mr. Butler. Let's take appearances from the parties.
Good afternoon. This is Tom Gressett on behalf of the petitioners.
Good afternoon, Mr. Gressett, and welcome. And who is here for Dominion Energy South Carolina?
This is Matt Gissendanner on behalf of Dominion Energy South Carolina, and with me today is co-counsel Chad Burgess.
Good afternoon, Mr. Gissendanner and Mr. Burgess. Welcome. And
Good afternoon. Thank you.
Office of Regulatory Staff.
Good afternoon, Madam Chairman, members of the Commission. Appearing on behalf of ORS is myself, Andrew Bateman.
Thank you, Mr. Bateman, and welcome. Any preliminary matters before we get started? Hearing none, Mr. Gressett, would you like to proceed?
Certainly. Thank you, commissioners. We are here today by virtue of our filing of
Mr. Gressett.
Yes, ma'am.
I'm sorry to interrupt. Can you tilt your camera down a little bit? We're kind of missing the bottom portion of your face.
Well, let's see here.
That's better. That helped. That helped.
Maybe I can sit up a little bit too.
Well, that helped. I don't want you to be uncomfortable, but we want to see you.
No, ma'am.
But we want to see you.
There we go.
Thank you. And my apologies for interrupting.
Oh, no worries. We're here today by virtue of a petition filed on behalf of Orangeburg County Solar Project, LLC, and Orangeburg South Solar Project, LLC. These two projects are, as you might imagine from their names, located in Orangeburg County and are proposed to operate as solar collection facilities producing less than 75 megawatts of energy. In conjunction with the design of the two facilities, the most appropriate way to proceed came with a connection of the facilities by virtue of about 200 feet of what's called KV line. When you have a facility that has certain qualities, characteristics, of course, as the commissioners know, it is subject to the Utility Facility Siting and Environmental Protection Act. Our concern and a reason for filing the petition was to confirm that this very short, approximately 200-foot line did not in some way convert these facilities into the type of large utility that is covered by the Utility Siting Act. We filed an application asking for a declaratory order after consulting with ORS. We felt that was the appropriate way to proceed. Following the filing of the petition, we engaged in responding to discovery with the Office of Regulatory Staff. As the Commission is aware, also Dominion Energy filed a petition to intervene and has intervened in the case. Following the exchange of information, I'll let, of course, ORS present its position. But following the exchange of information, I believe that the ORS's position is in support of the relief requested. And so, in short, the relief requested is in order that the facilities as outlined in the materials provided to the Commission and to ORS do not meet the definition of a major utility facility under the Utility Facility Siting Act, such that a certificate of compliance would be required. In order to be subject to the Siting Act requirements, the facility at issue must be what's called a major utility facility. And the statute itself in 583320, excuse me, defines the term major utility facility. And there are two portions of that definition that are at issue today. The first is whether the generating plant and associated facilities are designed for, capable of operation at a capacity of more than 75 megawatts. The second definitional question for us today is whether we have an electric transmission line and associated facilities of a designed operating voltage of 125 kilowatts or more. I'll start with the second, if it's all right. As I explained to the Commission, these two projects are connected by approximately 200 feet of what's called a GenTie line. And that GenTie line is a 230 kV line. It exceeds the kV threshold listed in Section B of the definitions if we read that definition strictly and require the projects to submit to a siting application, then we would be saying that even a short 200-foot line is the kind of large facility that the Siting Act, as the legislature intended, was created to regulate. It's the petitioner's position that this short line does not transfer or transfer, does not change the facility as designed into a major utility facility. That is based on not only the length of the line, but also the fact that multiple other states, as cited in the petition, have similarly ruled that when facilities are equipped with only one line that exceeds a base number, as this one does, and if that line is less than a mile, sometimes less than 2 miles, that they should not be classified as a major utility facility for Siting Act purposes. The second issue that we have to address today is questions regarding the 75 megawatt threshold and whether or not these facilities are capable of, designed for, or capable of operation at a capacity of more than 75 megawatts. The way these systems work, and forgive me if I'm being redundant for the Commission, the solar panels gather energy. Energy is sent to what's called an inverter in DC current. At the inverter, it is converted into AC current. Then it is sent to a substation. In this instance, the projects would share a substation, and from the substation, there's the 230-foot kV line, and then the power goes out to the grid. One of the questions that has come up through Dominion's filings is whether or not this 75 megawatt limit is accurately portrayed by the information we've provided. That's the best way I know to put it. Each of the inverters for the projects has a real power curtailment system that's a computer program that prevents it from putting more than 75 megawatts of AC current out to the substation and then out to the grid. The reason it needs to be less than 75 is because that's what the agreements with the electric utilities will say, right? So if you have an agreement where you cannot put out more than 75, or they haven't agreed to allow more than 75, you can't put it out on the grid. So these computer programs are set up by the manufacturer. They are programmed into the inverters, and then the inverters have a cap. In this instance, one facility is 73.98 megawatts, the other is 74.9 megawatts. The settings on these inverters cannot be changed unless the manufacturer is involved. According to the interconnection agreements, the electric utility has to be notified. Most times the manufacturer won't do it unless it knows that all parties are there. But the interconnection agreements require that the electric utility be notified, and everyone must participate if there is ever to be a change to this setting. What petitioners are arguing is that, what interveners are arguing is that we have installed inverters that have a nameplate capacity that is slightly higher than this inverter limited capacity, and that the commission should look at the nameplates, and that what the legislature intended when they wrote designed for or capable of operation at a capacity of more than 75 megawatts means look at the nameplate. Petitioner's position is you do not look at the nameplate, you look at the capacity that is limited by the inverter and what can be placed out on the grid. In support of that position, I would make note that the legislature in 584120, with regard to avoided cost calculations, makes a specific reference to aggregate nameplate capacity. Again, in South Carolina Code, annotated section 1237-20, talking about renewable energy resources and taxation, the legislature uses the phrase nameplate capacity. I point these sections out because they are consistent with our argument that if the legislature intended to apply nameplate capacity in section 2A of the Siting Act, it would have said nameplate capacity. Instead, it used a different phrase, which when applied to the technology and the practice in the industry, indicates that it is a measure of the power in megawatts that can be produced from the inverter as limited by its structure and these additional limitations that are placed on it. There is some concern from the interveners that we have, as they call it, decoupled in our argument the Siting Act's protection for land and its concern over the size of the generating facility's footprint. Okay, so the argument is we have, in pointing this out, separated the test from the statute, which they assert is concerned with the generating facility's footprint. We did not do that. The legislature did that. The legislature provided what the definition of major utility is. We've been talking about those, and it is not the footprint of the plant. The final thing that I'd like to talk about with regard to the interveners' positions is, in essence, they are asking this commission to improperly engage in a hypothetical consideration of facts that may or may not exist in the future. They don't exist now. It's asking for a precautionary or preliminary ruling that if a utility like the petitioners installs an inverter that has these formal and real limitations on it, it's asking the commission to rule that automatically it's subject to the Utility Siting Act because someday later, in this imaginary scenario, this solar producer, the petitioners, could sneak back in and take that inverter off or somehow alter it and create more power in excess of the 75 megawatts. Well, as I explained earlier, this is not a switch they can just flip. There are multiple technological steps involved. There are multiple contractual provisions that would be triggered, and there are also regulatory provisions that would be triggered. If the petitioner were to suddenly start producing more than 75 megawatts, then it needs to talk to the commission about a Siting Act approval. They're not going to do that. And there's a real practical reason. It costs about $1 million per megawatt to create a facility like this. It does not make any sense, as the interveners assert, that a developer would add an additional 500 megawatts on the collection side, only put in a 75 megawatt converter to sneak in under the Siting Act, and then come back later at some unknown time after investing hundreds of millions of dollars and try to change the inverter to put more power on the grid. One, it's not practical. No developer is doing that in this case. Number two, it would cost way too much money for it to make sense to anybody. They would just build another less than 75 megawatt facility if they didn't want to have a facility subject to the Siting Act. Finally, there is a contract that will govern how much power this facility can put out on the grid. It can't just decide it wants to put out more AC power on the grid. It has to have an arrangement with somebody. And in this instance, that arrangement is for 75 megawatts or less. So this idea that there is a hypothetical potential maybe situation where some unscrupulous developer would come in and engage in these very unprofitable, impractical things is just not relevant, and it doesn't support a ruling against the requested relief. In the present case, if you look at the Siting Act and what is required for a certificate, these facilities are not those kinds of facilities. If you want to obtain a certificate or are required to obtain a certificate under the Siting Act, it is no small endeavor. I'm looking at the list of exhibits that came in with the application for Certificate of Environmental Compatibility in case 2020-43E. The application came not only with the information included in it, but there was a windshield survey, a visual impact assessment, aerial analysis, land use analysis, building analysis, public impact, population, socioeconomic factors, aviation, farm analysis, wetlands, hydrogeology, flood impacts, natural resources, cultural and archaeological surveys. It is a huge undertaking to be subject to the Siting Act. And the legislature has said, if you are greater than 75 megawatts, you should be subject to the Siting Act. If you are not, then you shouldn't be subject to these kinds of burdens, because you're not presenting the kind of risk that the statute is designed to prevent. So, for all of those reasons, the petitioner has, as a precautionary measure, asked that the commission issue a declaratory order ruling that the facilities as planned do not constitute a major utility facility such that it would require a certificate under the Siting Act.
Does that conclude your statement, your argument, Mr. Gressett?
Yes, ma'am.
Thank you very much. Commissioners, any questions of Mr. Gressett, or do commissioners prefer to wait and question attorneys at the conclusion of all the arguments? Okay, we have one that says at the conclusion of all arguments. So, thank you, Mr. Gressett. You may be called upon shortly.
I'll stand by.
Thank you. Dominion Energy, Mr. Gissendanner, will that be you today?
That will be me.
Good. Please proceed when you're ready.
Thank you, Vice Chair Balzer and members of the commission. Matt Gissendanner on behalf of Dominion Energy South Carolina. Dominion Energy's purpose in intervening in this matter is to promote transparency and assist in the development of a full record so that the implications of the commission's decision in this docket is clear. The company wants to ensure that the commission, through its decision in this matter, does not inadvertently adopt a standard that ignores the purpose of the South Carolina Utility Facility Siting and Environmental Protection Act and limits the jurisdiction of this commission as well as other state and local government bodies. On page 1 of their petition, solar developers framed their request of the commission as follows: the issuance of an order confirming, quote, the Orangeburg County Solar Project and Orangeburg South Solar Project, collectively the projects, do not meet the definition of a major utility facility as defined in South Carolina Code 583320, merely because they will share a single 200-foot, 230 kV generation gen tie line. This statement makes the unsubstantiated legal conclusion that each plant individually does not trigger the Siting Act. Dominion Energy respectfully requests that this commission either limit any order only to explaining the impact of a generation tie line without ruling on whether the underlying projects individually trigger the Siting Act, or 2, evaluate whether the generating facilities trigger the Siting Act, given that each generator is designed for or capable of operation at a capacity of more than 75 megawatts, and then determine the impact, if any, of the gen tie line. If it chooses the latter course, based on the information provided by solar developers today, we believe that the commission must find that the projects are subject to the Siting Act. This clarification is critical because if the commission grants the relief requested by the solar developers, it could have the unintended consequence of establishing commission precedent regarding the standard for determining whether the Siting Act is triggered. The Siting Act is triggered when a project is designed for or capable of operation at a capacity of more than 75 megawatts. The solar developers are subtly trying to slide a new standard past you, ignoring the purpose of the Siting Act and the various government entities who are charged with evaluating a project's impact on environmental and land use regulations. The solar developers want you to adopt a new standard that compares the 75 megawatt threshold against the amount of power a generating facility can inject onto the grid at any one point of interconnection. Dominion Energy in this proceeding seeks to highlight to the Commission the significant change that solar developers are truly seeking, and Dominion Energy opposes the adoption of this new standard as it would violate the purpose of the Siting Act. To highlight the purpose of the Siting Act and the implications of the developer's request, I would invite the Commission to look at Section 5833-120, Application for Certificate. In addition to requiring that an application contain a description of the location and of the major utility facility to be built and a summary of any studies which have been made by or for applicant of the environmental impact of the facility, that section also requires that the application be served on the Office of Regulatory Staff, Chief Executive Officer of each municipality, and the head of each state and local government agency charged with the duty of protecting the environment and of planning land use in the area in the county in which any portion of the facility is to be located. It is clear that the Siting Act is concerned with, among other things, the footprint of the project. Because this footprint is in part determinative of the environmental impact and any land use impacts of the project, it is unreasonable and contrary to the Siting Act to allow a developer to construct a 100-megawatt facility but evade state environmental review as well as state and county land use review simply because the plant is paired with a limiting device like an inverter or other governing device that restricts the amount of power that may be injected to the grid. Such a standard would also deny the opportunity for impacted third-party intervention and arbitrarily deny these parties the right to be heard. The solar developers should be transparent with this Commission about the design and capability of the proposed generating facilities. And it is the megawatt DC direct current rating that determines the size of a solar facility, not the megawatt AC output. This is a critical distinction because a project's output in megawatt AC can be artificially limited, as solar developers indicate they are doing here, to a number less than 75 megawatts, while its megawatt DC rating capacity could be a much larger number. Furthermore, these limiting settings can be modified at any time during the life of the facility to exceed the 75 megawatt threshold while avoiding any review under the Siting Act. This would lead to absurd results and create perverse incentives. For instance, let's assume another developer chooses to construct a facility identical to the one Savion proposes here, but chooses to set the inverter such that the output of the facility is 75.1 megawatts. Under Savion's logic, that facility would be subject to the Siting Act and Savion's would not, even though they are the same size, with the same land use, the same environmental impact, the same number of trees cut down, and the same amount of farmland cleared to make way for the panels. Analyzing the megawatt DC rating of a project is critically important because it speaks to the overall footprint of the facility and corresponding impact on the surrounding environment as well as local land use regulations. As outlined in DESC's proposed order, these environmental impacts are a primary concern of the Siting Act. Now, ORS requested the megawatt DC rating of these projects in discovery, and the Commission also requested design information. Despite these specific requests, solar developers have refused to provide this specific information and continue to point to external limitations on the send-out capacity, even though such limitations are irrelevant to the project's actual design and generation capability, which is the concern of the Siting Act. Although the solar developers have refused to provide actual values, solar developers did acknowledge what DESC suspected and outlined in its responsive comments. In their response to ORS, they stated that it is normal for solar projects to possess a megawatt DC rating of the solar panels that is 1.3 times to 1.4 times that of the megawatt AC rating of the inverters. If these multiples are applicable to and hold true in this case, the megawatt DC ratings for the projects in the Santee Cooper queue fall within the range of approximately 96 megawatts DC to 105 megawatts DC, and would certainly require a certificate of public convenience and necessity and environmental compatibility under the Siting Act. DESC educated guess that the megawatt AC rating of the project was not indicative of the actual footprint of the projects was correct. These projects are capable of operating at a capacity of approximately 100 megawatts DC, which connotes a much larger footprint than the approximately 75 megawatt AC rating of each project would imply. In fact, the Siting Act seems to expressly acknowledge this point by stating that the facilities meeting the 75 megawatt threshold are those that are designed for or capable of operation at a capacity of more than 75 megawatts. Not only did solar developers fail to disclose this distinction in the petition, but their response to a separate ORS discovery request indicates that solar developers have not consulted with DHEC, the Department of Parks, Recreation, and Tourism, or the DNR regarding the petition, each of which are entities recognized as interested stakeholders by the Siting Act and are required to be parties to hearings conducted thereunder. These state agencies must be allowed their legislative right and obligation to review this and other similar siting applications, and that right should not be limited based on artificial limitation on these projects, particularly whereas here that could be modified at a later date. Such an exception would completely negate the legislature's establishment of the Siting Act. In short, the Siting Act evidences a clear concern for more than just the delivery capacity of the generators, which can be manipulated up or down. The record is absent of any material evidence related to these other factors. DESC maintains that the megawatt DC rating of these projects is the relevant data point under the Siting Act. The projects are capable of operation at greater than 75 megawatts and thus should be required to obtain a certificate under the Siting Act. Now, before I turn to two other small matters, I wanted to address one comment that was made by counsel for the solar developers. And I believe he indicated in his argument that the ORS had supported solar developers' request. At best, that is a charitable reading of the ORS letter. At worst, it's a gross mischaracterization. The ORS letter is clear in its recommendation that based on its review, and I'm quoting, based on its review of the aforementioned information, if the commission issues an order confirming that the projects do not meet the definition of a major utility facility as defined in the Siting Act, ORS recommends that the commission provide in the order that, and then they offer two recommendations for the commission to include in the order if the commission makes that conclusion. So in its letter, the ORS does not make a determination one way or the other whether the project meet the definition of a major utility facility, and they simply say if the commission makes that determination, then they recommend that certain provisions be included in the order, and I wanted to be very clear about that. Now I briefly want to turn to the solar developers' request that the commission find that the projects are not major utility facilities requiring a certificate merely because the projects will share a single 200-foot, 230 kV generation tile line. Dominion Energy did not take a position on this specific request, and we likewise have not taken any position on whether the commission may create exceptions to the need for a certificate that are not specifically enumerated in the Siting Act itself. And this question is separate and distinct from the standard for determining whether a proposed project on its own triggers the 75 megawatt threshold. Therefore, any answer to this question should be narrowly tailored so as not to inadvertently establish a new standard for determining whether a project meets the 75 megawatt threshold under the Siting Act. And then finally, I just want to briefly address Dominion Energy's concern related to the 1 mile rule. The solar developers petition simply stated that the projects are separated by approximately 1 mile. This is a consideration that is relevant under PURPA's maximum capacity calculation, but not relevant to the Siting Act 75 megawatt threshold. At a high level, under PURPA, for facilities that are separated by approximately 1 mile, there is either an irrebuttable presumption that the facilities are located at the same site, or a presumption subject to rebuttal by the utility that the facilities are located at separate sites. This analysis determines whether the capacity of the facilities is aggregated to determine whether the facilities can obtain QF status. So in essence, under the 1 mile rule, because these projects, by virtue of what petitioners have provided, are greater than 1 mile apart but less than 10, Santee Cooper would have the right to rebut the presumption that these are separate projects and argue that they are one and the same. And if they are one and the same, then under PURPA, that they would be equal to 150 megawatts, and Santee Cooper would not be subject to the must-take provision under PURPA. In any event, the commission is without jurisdiction to address compliance with FERC's 1 mile rule, and neither the petition nor the Siting Act require the commission to address whether the project's capacity should be aggregated. Therefore, DESC respectfully requests that the commission avoid any holding that impacts FERC's 1 mile rule, thereby fully preserving FERC's right to determine these issues. The commission, I would note that the commission can address the impact of the gen tie line, if any, and or whether the proposed generation facilities trigger the 75 megawatt threshold of the Siting Act without ruling on the impact of the plant's location to one another. In conclusion, DESC respectfully requests that the commission either limit any order to explaining only the impact of the gen tie line without ruling on whether the individual projects trigger the Siting Act, or evaluate whether the generating facilities trigger the Siting Act, given that each generator is designed for or capable of operation at a capacity of more than 75 megawatts, and then determine the impact, if any, on the gen tie line. As I've stated, the petitioners have not provided the specific relevant megawatt DC rating in order to do the analysis for whether they fall under the 75 megawatts of the Siting Act. However, based on the information provided and the statement to ORS and to the commission, that it is typical that it is 1.3 times, that the DC rating is 1.3 to 1.4 times the AC rating of the inverters, based on that information provided by solar developers to the commission on October 14th. If the commission decides to evaluate whether these units are capable of operation at a capacity of more than 75 megawatts, DESC would respectfully request that the commission deny the petition and hold that each project qualifies as a major utility facility under the Siting Act, because the 75 megawatt threshold under the Siting Act is based upon the megawatt DC capability of the solar projects. Finally, we would just request that any order issued by the commission in this docket should clearly indicate that such order is based upon the limited set of facts in this record and is not precedential or binding for the purposes of any future analysis under FERC's 1 mile rule or under PURPA. Thank you, Madam Chairman. I'll be happy to answer any questions that you all have.
Thank you, Mr. Gissendanner. I think we're going to hold questions until all arguments are completed. And so we will recognize Mr. Bateman from ORS.
Thank you, Madam Chair. My only brief comments would be to address the comments made by both Mr. Gressett and Mr. Gissendanner with regards to ORS's position. Mr. Gissendanner correctly read a portion of ORS's recommendation. I want to make clear that ORS's recommendation is, in the event the commission does not find that these facilities meet the definition of a major utility facility, that in the future, should these facilities exceed the 75 megawatt threshold, the commission require that they come in to be cited, and that the commission narrowly tailor this order to this specific case, such that it's not broadly applicable going forward. I know my comments were relatively brief, but I did just want to address the comments made by both Mr. Gressett and Mr. Gissendaner with regards to ORS's position. Thank you, Madam Chair.
Thank you, Mr. Bateman. Commissioners, question?
Oh, I'm sorry. This is Tom Gressett. I wondered if I might respond quickly.
Yes, sir. Go ahead.
Thank you. I apologize if I, in haste, mischaracterized the letter from ORS. But as the commission can see, since the appearance of Dominion in this case, the solar developers and its lawyer have been now accused of subtly trying to slide new standards, not being transparent. It's just not correct. Megawatt DC is not used in any other circumstance as the interveners are suggesting it be used in this case. The reason that there is not a precise megawatt number to be provided is because megawatt DC is the amount of solar energy collected by the panels that goes to the inverter. Until actual purchase is made of the solar panels, it won't be known exactly how much power comes from them to the inverter. The reason being, there are times when larger collection devices are more cost effective than multiple small ones. And so the number just isn't determined until they buy the equipment. There's no secret, and there's no desire to create a new standard. I mean, you know, somehow these folks came to me and said, let's please go to the commission and be sure that we're doing the right thing, and they've been turned into villains. We don't want an order that goes beyond this case. We will come back if we want to change anything to greater than 75. We don't want a finding about the FERC 1 mile rule. We don't want a finding about 1 mile. And we're not trying to advocate for a new standard. The goal was to obtain a ruling from the commission focused on this KV line so that the companies could be sure that they were in compliance with all Siting Act requirements. If I have failed my folks in presenting that and led anyone to think that I was hiding something or not being transparent, I certainly apologize. Thank you.
Thank you, Mr. Gressett. Commissioners, I see Commissioner who's speaking?
This is Commissioner Irvin.
Commissioner Irvin, please go ahead.
Thank you. Mr. Gressett, it's good to have you and opposing counsel with us this afternoon. Is it true that your clients' projects are still in the queue at this time?
Yes, sir. They are in queue with Santee Cooper, and technically I think there may be one of the projects is pending in the Dominion queue. That is, of course, because it's a matter of practice when you have a site that you might make multiple applications. But yes, sir, they are still in the queue.
Did your client consider amending your application to sell through a power purchase agreement solely to Santee Cooper, which would eliminate Dominion's standing, I suppose, to challenge it?
That is the plan as of now, Your Honor. I think, can look at my notes to be sure, but as I understand it, we are proceeding under the assumption that the agreements will be with Santee Cooper.
Well, then I'd like to ask Mr. Gissendaner, if Dominion Energy South Carolina is not going to have a power purchase agreement with Mr. Gressett's client, why do you have standing to oppose it?
Mr. Commissioner, we've already been granted the right to intervene. We were very clear in our intervention petition that the Savion has 3 projects in 2 queues. They have these 2 projects in the Santee Cooper queue. They also have another project, Orangeburg County Solar, by the same name in the desk queue. And we were intervening because of our interest as a regulated public utility underneath the Siting Act, and we clearly have an interest in any interpretation of the Siting Act. Moreover, I would note that even had we not intervened, this is a question of the commission's jurisdiction, and so it absolutely is something that the commission has to consider. So we've been granted intervention. There is no doubt that we have standing given our interest in the interpretation of the Siting Act, specifically as it relates to solar QFs and solar facilities, and for that matter, any other facility. Were the commission to adopt the standard that is being proposed by the solar developers in this docket, that standard would not just be applicable to solar developers, it would be applicable to Dominion Energy South Carolina, to Duke Energy, and also to any independent power producer who was seeking to site a facility in South Carolina. For instance, we know in 2004 or about that time, Calpine Energy cited the Columbia Energy Center in a citing proceeding before this commission. That was not a QF citing, but certainly a ruling that says that a solar developer can build a 100 megawatt or greater DC solar facility and then evade Siting Act review simply by setting its inverter at an arbitrary setting that takes it under 75 megawatts for what is injected onto the utilities system. That would certainly impact that independent power producer and would allow someone to build, say, an 80 megawatt, maybe something an 80 megawatt gas facility and put a governing device such that it only injected 75 megawatts onto the company's system. And that clearly is not what the Siting Act was intended. Mr. Gresset, in his answer earlier, indicated that and you brought up the interconnection queue. In his response to the commission, he made much of definitions in the LGIP, which is a FERC document, or the South Carolina Generator interconnection document and the FERC form. What the FERC and the interconnection, the FERC forms and the interconnection protocols are concerned with, they are concerned with what is injected onto the company's system. The electric system is AC current. And so AC current, it is important for those types of proceedings, how much AC current is being injected onto the system. That's what those are concerned with. The Siting Act is concerned with land use and environmental concerns. AC current has nothing to do with that. What determines the number of solar panels determines the DC rating. That doesn't change. So he's trying to tell you that he doesn't know what the DC rating is. That's not what they told ORS. ORS asked for the DC rating, and the response from the solar developers was, that's irrelevant, but usually it's 1.3 to 1.4. So they've been asked about that by ORS. They've been asked by this commission for design considerations, and they refused to provide that information. Moreover, I would note that he indicated that the megawatt DC is based on the solar energy collected. In order for solar energy to be collected, it's got to be generated. And that's exactly what the Siting Act is referring to. Thank you.
Well, back to my original question, if Mr. Gressett's clients withdrew their application in the Dominion Energy South Carolina queue, doesn't that eliminate your concern? It then becomes a Santee Cooper concern and not a Dominion Energy concern. True?
No, it does not. Again, our concern is with the interpretation of the Siting Act. and any interpretation of the Siting Act that the commission issues here would be clearly applicable to Dominion Energy. It has nothing to do with whether or not this project is in our queue. We have no problem with this project. Our concern is with the interpretation of the Siting Act, and we clearly have standing.
I understand what you're saying, but ORS in its letter said that we could limit the applicability of any decision by saying and holding that it has non-binding precedental value in future projects. So that would eliminate and alleviate any concerns that the Dominion has as it relates to other future potential projects. True?
Respectfully, Mr. Chairman, ORS did indicate as such, and originally in our original petition, Dominion indicated as such when it was not clear, when it appeared that they were only seeking an evaluation of the Gentile line. Now, as Mr. Gressett has made clear, it is clear that they are seeking an interpretation of the 75 megawatt threshold, and respectfully, to the extent that the commission were to say that this is, I don't really see a basis for limiting that decision only to the facts of this case, unless this commission were simply trying to favor solar developers over generation constructed by the utility and independent power producers. So unless you're favoring solar developers, I really see no basis for limiting this just to the facts of this case.
Well,
with respect to the 75 megawatt threshold question.
Yes, sir. I don't believe anyone's trying to favor one side or the other. I think that's why ORS suggested in its letter that we should, if we do go that route, and I'm not saying that we should, I want to hear everyone out in this matter, but in the event that the commission decided to allow this project to go forward, we could have a language that has no precedental value. And that's ORS's opinion. You understand that?
I understand that that is ORS's opinion. I also understand that this is a jurisdictional matter for the commission. And again, I don't believe that there is any basis for the commission to say, we don't have jurisdiction in this matter, but this is only binding on this one company and not precedential for any other companies that you regulate or any other companies that might come in and seek a siting certificate. This is a jurisdictional question, and respectfully, I don't believe that you're able to say, well, we don't have jurisdiction here based on these facts, but if these same facts come along in another matter, we may have jurisdiction. That simply, I don't believe that withstands logic or legal scrutiny.
And the final question I have is, you could have a further requirement that the applicants shall be required to notify the commission if at any time they exceeded the limit of power being put on the grid. That would be further protection, would it not?
You could certainly do that. I believe that was also one of ORS's recommendations. And with all due respect to ORS, I believe that recommendation is a bit nonsensical. In that case, what you would have is you would be saying that, well, if you later adjust the AC, the plant is not going to change. The number of solar panels in the field and the amount of energy, solar energy that's being generated is not changing. What they would be changing is the AC inverter setting such that they would be changing the amount that they are injecting onto Dominion Energy system. But the projects would already be built. And so they would have already been constructed without any input from this commission, without any input from the local municipalities or the state or county departments that oversee environmental ramifications and land use. And so, quite frankly, I'm not really sure what the point of a review would be at a later date if they decided to increase the AC setting. But again, the AC setting is irrelevant. The AC inverter setting for solar panels is irrelevant to the question of the commission's jurisdiction under the Siting Act. It is the DC rating of the solar panels. That's not going to change. There's going to be a number of solar panels out in the field. They're going to be producing, if the multiples that were provided in discovery to the ORS and the commission are true, the output in DC is between 96 and 105 105 megawatts DC, well over the Siting Act threshold, and no change in the AC inverter setting is going to change that. So it really, the ORS's suggestion again seems nonsensical to me, in that the plants, you would be saying you can go ahead and build the plants because you've adjusted that setting below 75 right now, but then if you go up, you're going to trigger the Siting Act. The plants have already been built without any supervision under the Siting Act.
Mr. Bateman, what do you have to say about that? Does it concern you that could occur in the future?
Thank you, Commissioner Irvin. To be clear, ORS does interpret the 75 megawatt threshold under the Siting Act as being applicable to AC. I believe that's how it's been interpreted traditionally by ORS, as well as my understanding is by the Commission and the utilities and developers. Moreover, as highlighted multiple times, under the Siting Act, the term major utility facility means and this is in part, electric generating plant and associated facilities designed for or capable of operation at a capacity of more than 75 megawatts. As Mr. Gissendaner mentioned earlier, the utilities system itself functions on AC. As a result, a facility could not be designed for or capable of operation by being injected into the utilities system unless itself was AC. And that really underpins our interpretation as to why the 75 megawatts is applicable to AC. For that reason, and based on the responses given by the Orangeburg solar developers in this case, ORS did make the determination that the 75 megawatt threshold was not triggered in this proceeding.
So the bottom line is that the ORS position is that the declaratory judgment requested by the petitioners should be granted with the conditions that you placed in your letter.
You know, Commissioner Irvin, I don't know that I'd say that actually and necessarily. We don't believe that the 75 megawatt threshold was triggered. You know, the second threshold discussed by Mr. Gissendaner earlier is the 125 kV transmission line. Mr. Gressett did mention earlier, I think about 200 feet of what he called a Gentile line does exceed that threshold requirement. I believe it's 230 kilovolts. As a result, I think the Commission would need to look at those two requirements, and it would need to make the determination, whether it believes that the 75 megawatt threshold was triggered in this case. And based on the information that we received, and from my understanding, ORS did not make the determination that the 75 megawatt threshold was triggered. That being said, the letter of the law does also indicate that a major utility facility means an electric transmission line and associated facilities of a designed operating voltage of 125 kilovolts or more. There is a relatively small, I think 200 feet or thereabouts, Gentile line in this case, which exceeds 125 kilovolts. And for that reason, if the Commission were to determine that this facility needed to be cited, ORS would have no objection.
Thank you. No further questions, Madam Chair. Thank you.
Madam Chair.
Thank you, Commissioner Urban. Commissioner Caston?
Good afternoon, Mr. Gressett, if I could ask you a couple of questions.
Yes, sir, sure.
Looking at the map, and it's approximate math, but if I've looked at it correctly, the total leased acreage is just under 4,000 acres. And the total fenced acreage is just under 1,400 acres. Is that correct?
I believe that's correct, sir. I have total of 1,655 acres leased for Orangeburg County. 390 would be used. The fence area is different than that. 350 acres would be used of the 1283 in the Orangeburg South plot.
The map I have says 1,665 leased, 785 acres fenced,
Yes, sir.
1,283 acres leased, and 590 acres fenced.
Yes, sir.
Okay. And I want to make sure I understand this too. As far as the two sites, will they be tied together at the interconnection point? Is that how that works? I see where it looks like you have an easement.
Yes, sir. They join into the same shared project substation. And then the substation is connected to the three-breaker ring, to the point of interconnection equipment by the 200-foot gen tie line.
Okay.
There is a exhibit A to the original petition that illustrates that a little better than I probably just described.
And listening to the various arguments, I was also thinking, you know, this 75 megawatt siting act and all those things, and I understand certainly the importance. But if the project exceeded 80 megawatts, then that would, I guess the project would not be able to obtain QF status or the must-take status. Is that correct?
Yes, sir. If the AC numbers that we're talking about in this project were 80 plus, then under that hypothetical situation, I believe it would be a major utility facility because it would be greater than 75. And a siting would be required.
Okay. And it also caused me to, you know, listen to, I think, some clarification or comment you made relative to panels and larger panels, smaller panels. If an electric utility, I was thinking if an electric utility, whether it's Dominion or whomever, said they wanted to build a 74 megawatt cogen facility, they had not purchased their equipment yet, but the equipment could produce up to 200 megawatts. Would that be okay? I mean, should that avoid the Siting Act?
The trick about that is, I don't know why a utility would spend that kind of money to have a facility it couldn't use, because presumably if it has 200 megawatts generating and is only approved or petitioned or been certified with 74 or under, then the additional, let's just say, well, the additional megawatts couldn't be used for anything.
All right, and let me readjust it hypothetically then, because just hypothetical.
Yes, sir.
Instead of 200, the equipment, I could do 85, to avoid, would that be okay? And to avoid the Siting Act?
Well, candidly, when I have posed these questions to folks in the industry, their response is always to scratch their heads and say, why would anybody do that? I, like you, have said, well, we're talking about technical numbers, right? And how do we measure them, et cetera. And then the response is the industry uses AC. AC is what we look at.
Okay, I understand that.
I
think I
do
do.
understand that ultimately where Commissioner is headed is if, as Mr. Gissendanner has suggested, someone wanted to build a very large footprint, right? That was not the kind of footprint that would normally be related to 74 megawatts AC, right? They wanted to build a huge facility. What result then? And I think the answer is that I can't fathom a situation where somebody would do it.
Well, what if, another hypothetical, the plan is to build a 74 megawatt unit, although the equipment could do up to 80, 85, 90, whatever,
Yes.
just say 80. But they acquired 3,000 acres. I'm not aware of anything that says they can acquire 3,000 acres, provided, I guess there's the justification. Possibly they could be thinking long range and, hey, we may expand that one day. That's still a lot of acreage.
Yes, sir, and I think that you have a sharp handle on the potential, right? You've got a good site and you can secure the rights to a significant amount of property. They can only have one facility on that parcel of property. They can't build another one just like it right next door later. Now, they could alienate their rights to a portion of the property and some other entity could come and develop it, but not these petitioners.
Maybe make a hunting reserve out of it.
Yes, sir. And when we talked a few minutes ago about the numbers, I think we have to go back to the industry as it existed, as it's used these terms when the statute was written, and candidly, if the legislature wants to change it, then they have to change it. But as it's written now, I think it's 75, refers to AC, and although that may lend itself to some hypothetical conundrums, I think it's how the statute's written.
Well, thinking back to, and I'm paraphrasing because I didn't write down exactly what you said, how you said it, but until the panels are purchased, you won't know exactly what it would be because sometimes larger panels are cheaper than the smaller ones. And I understand that. I mean, hey, I'll get the 2 for 1 any day. Give one away if I have to. But that said, that those are big sites. And if it is, instead of 75, the panels come back and they're, 120 megawatts. And I know you've got whatever governor, used to have a go-kart that had a governor and it used to drive me crazy. So I understand that, but is it really splitting hairs?
I do think that the petitioner has been forthcoming about the fact that generally the megawatt prediction in the industry and for this project is 1.3 to 1.4. Somebody may have said 1.5, that's fine. That is the ratio of DC to AC that generally provides the most economical and efficient production so that the facility can consistently put the most available power up to the 75 on the grid at all times of the day.
Understand. And as I was looking at the map, thinking about it, looking at the interconnection, and I didn't have a scale to really, and I don't know how accurate the scale is on the map anyway. But that said, could an argument be made that the proximity of those two sites would make it one facility at around 150 megawatts?
Well, it's totally separate owners. I mean, separate entities own the facilities.
And not the same parent company, they're just totally distinctly
They are
different?
wholly owned subsidiaries of the same parent company.
Okay. Attorney Bateman, do you mind if I ask you a couple of these?
Not at all, Commissioner.
Thank you. And I know it was the hypothetical, you know, relative to Cogen 74 versus 80. What's the distinction, or is there a difference? In other words, the way we're being asked to view this project versus if that were the situation with a utility, like the hypothetical I gave you, can you kind of tell me where the distinction would be, why they would be different, or is it really the same?
Commissioner, you know, it's hard, honestly, to answer hypotheticals. There are so many variables that may be at play. Each factual situation is unique in and of itself. And so I don't want to give you an answer that is unhelpful. So I think, if it's okay with you, I'll give you some of the facts and you can let me know if there's, something else that may be more helpful. I do think, and I am certainly no engineer, and I don't want to give anyone the wrong impression, not that I could, honestly, but based on my understanding, it is true that DC output may exceed AC output. It is also true, based on my understanding, that ORS, other entities, the commission, have traditionally interpreted the 75 megawatt threshold as AC. And as a result, based on my understanding, there have been projects in the past which were not required to be cited where their DC output may have exceeded 75 megawatt because their AC output did not exceed 75 megawatts. Hopefully those facts sort of illuminate the way in which you're looking at the hypothetical you gave, and hopefully those offer you some help.
You handle that like a very good lawyer. And I expected nothing else from you. I appreciate that. Give me a minute because I'm trying to think how to phrase it so it won't be hypothetical. Well, while I'm thinking about that, let me ask you something else, because you said in the past, you know, similar things have been done or relative to DCAC. So were they precedent setting, or is it something maybe that was done in the past that, well, you don't always have to do it that way?
Mhm. Sure. Commissioner, without having this case law at my fingertips, based on my understanding, commission order in general is not precedent setting. That being said, my understanding of that theory underpinning that fact is that despite the fact that commission orders are not technically precedent setting, the commission may not, and this is a paraphrase, and without this case law at my fingertips, I honestly hate to even give it because I don't want to butcher it. But without sufficient justification, which would enable the commission to veer from past practice, it may not. Now, again, take that with a grain of salt, Commissioner. I do not have that case law in front of me, but that informs my opinion as to whether or not those previous orders would be technically precedential, precedent setting.
Understand. Good answer. And I pose this to Mr. Gressett. Why should these projects not be viewed as one project, given circumstances? I mean, these are pretty big sites and they're pretty close to each other.
Yes, Commissioner, and I think that it sounds like you were getting at the 1 mile FERC rule, as Mr. Gissendaner and Mr. Gressett have both discussed. ORS does not have a position as to whether or not these sites ought to be viewed as one site, though I will reiterate what I think Mr. Gressett mentioned, and Mr. Gissendaner may have also mentioned, that despite the fact that there may be a single parent company, it is two separate owners of Orangeburg and Orangeburg South, I believe maybe the other entity.
And whether they have the same parent company or not is not really relevant, or?
Not to my knowledge, though. Again, Commissioner, it is not an issue into which ORS delved deeply as to whether or not it was a single site or two separate sites.
Okay. Mr. Gissendaner, I feel like I ought to ask you a question. I don't want you to feel left out.
I'm ready, Commissioner. And if you don't, I have a couple of points I'd like to make to some of the questions that you've already asked.
Well, if I could ask you basically the same question I just asked Mr. Bateman, should the projects be viewed as two separate projects or one project?
So, for purposes of PURPA, I don't know the answer to that. I don't know enough about it. I think that it's, I don't know enough about these two projects from the PURPA perspective. I don't think, to me, it's not really all that relevant that you've got two separate LLCs under the same parent. That seems to me more like a game that somebody would play to try to say that they're independent projects. But you know, as far as PURPA, I think that Santee Cooper or whoever these projects ultimately end up being interconnected to would have to study that. For purposes of the State Siting Act, I don't know that question has been answered. Dominion Energy in this proceeding has not taken the position that they are the same project. We've treated them as two separate projects, each of which, if the multiples that Savion has provided for DC to AC current, each of which Dominion believes is capable of producing well in excess of 75 megawatts DC. I recognize that ORS has somewhat staked out a new position here a few moments ago that was not included in their letter to the commission, where they are now saying that past commission precedent interpreted the Siting Act as AC. I would note that AC is not referenced anywhere in the Siting Act. It simply refers to what the facility is capable of generating. I would also note that, at least to my knowledge, I'm unaware, at least in the past decade or so, I'm unaware of any solar facility that has brought the question of siting before this commission. So I would think that this one, at least as it pertains to the application of the Siting Act to solar facilities, is one of first impression. It would not be. It's unsurprising to me that a prior siting decision with respect to a coal unit or a gas-fired unit or any other traditional utility unit would have focused on the AC current, because for those units, the AC current is what they operate in. That's what they produce. They produce AC current, and that's what determines their size. For a solar facility, as Mr. Aggressive acknowledged, solar facilities generate DC current, and that current is then collected and it is sent to an inverter, and that inverter converts that DC current to AC current. And so the DC current, the number of panels, the DC current is what determines the size of the solar facility. And so to hold that the AC inverter setting of a solar facility is what is applicable for purposes of the Siting Act completely stands the Siting Act on its head, as the Siting Act is concerned with the land use and the environmental impacts of the facility's footprint. And these footprints, as you've noted here, I believe, I don't have them in, let me see here, I believe the fenced areas at least were 785 acres for one of the projects and 590 acres for the other project. I had someone do a rough calculation for me earlier today, and the company's 400 megawatt Cope station, which was cited before this commission, its fenced area, including the ash ponds and the plant itself, is approximately 430 acres. Give or take 10 acres. So we're talking, and that produces 430 megawatts of AC power. So we're talking about more than almost 4 times the generation for an equivalent or even smaller amount of acreage. And so I just think it defies the purposes of the Siting Act to say that we're going to look at an arbitrary limiting setting on an inverter to determine whether the Siting Act is applicable to solar facilities when it is plainly. And I think I am an engineer. I'm not an electrical engineer. I spent a few weeks at Clemson in an electrical engineering class, but I understand enough to know that the DC current is what determines the size of the solar facility. One other point that I wanted to make, I believe you were asking some questions about PURPA and the 80 megawatt threshold. I want to be clear that, and I stated this earlier, PURPA is concerned with the AC injection. And so if this commission were to hold that, as Dominion argues, that for purposes of the Siting Act, the relevant size is the megawatt DC rating, that would in no way, assuming that they have the inverter set such that the AC rating is less than 80 megawatts, that would in no way relieve the utility from its PURPA obligation, because PURPA is concerned with the injection. But the Siting Act is concerned with the generation. And as Mr. Aggressive acknowledged, the panels generate and collect DC power. And that's why it only makes sense that the Siting Act, with respect to solar facilities, use the DC rating of those facilities. Second, you asked the question related to the utility, and I think you first posed the question Mr. Gressett said, well, why would a utility buy a 200 megawatt generator if it could only use 75? But I don't think we even have to go that far. My understanding is that with respect to, say, gas turbines, that my understanding is that you can't just walk in to, say, GE and ask for a, 25, 26, 27, 28, every specific 1 megawatt increment size gas turbine. That these companies provide gas turbines. Say they might offer a 30 megawatt gas turbine, a 55 megawatt gas turbine, and an 80 megawatt gas turbine, or a 90 megawatt gas turbine. And if you needed the power, it may make the most economic sense for a utility to purchase an 80 megawatt gas turbine or a 90 megawatt gas turbine, and then limit the, through whatever artificial means, limit the output of that facility to less than 75 megawatts in order to evade Siting Act review. It might make sense. Now, do I think the utility would do that? No, we've never tried to evade Siting Act review as the solar developers are doing here. And I understand why Mr. Gressett's doing it. I've been through numerous siting proceedings, and he's right. They take a lot of work, and if you don't have to do one, that's good. But nobody's trying to evade the Siting Act except for the solar developers here. And then just again, if you are to find that the Siting Act, the arbitrary megawatt AC rating, which I think Mr. Aggressive has now said it could be set at 1.5. First it was only 1.3 to 1.4. Now he said today, maybe somebody said 1.5. We've certainly never said that. That's a new number. I believe, I don't know what the range that these inverter settings can be set at, but if the commission agrees with the petitioner, the commission may be fine with limiting its jurisdiction and giving up its say-so in these siting matters. But what you're also doing is giving up, is limiting the ability and the rights that DHEC, that DNR, that the Department of Parks, Recreation, and Tourism, that the municipalities and the county departments responsible for environmental land use and for land use and environmental control, all of those entities are given rights under the Siting Act. And if the commission says that no, these projects don't apply, or that this project isn't subject to the Siting Act, then you're also limiting those entities' rights to review these projects and have their say on them as well, which the statute grants. So that's all I have, unless you have any other questions.
I have one final question for Mr. Bateman, and I'll quit, I promise.
Yes, Mr. Commissioner.
And I do not have the Siting Act here in front of me, and I've just heard it said a time or two, and I vaguely remember this, I think, but where it does talk about designed or capable of producing, and that's something that I'm still kind of struggling with, I guess, relative to the argument that whether it's AC, DC, designed or capable of producing seems to me not to be relevant to DC, AC, or anything. It's just it either is or it is not capable of producing. Am I misunderstanding that, or?
Well, Mr. Commissioner, I again can tell you how ORS has interpreted it. One, I guess, slight point of clarification, Mr. Gissendaner earlier mentioned that ORS for the first time asserted its commission precedent that AC is the appropriate manner to interpret the 75 megawatt threshold. You and I had a discussion about precedent and the precedential nature of commission orders. I do believe in the past the commission has, and entities, or at least ORS, has viewed the 75 megawatts as AC, though I didn't intend to state that there was commission precedent that it was AC. So to the extent I misstated that, I apologize. Now, regarding your question as to designed for or capable of operation, I think when we look at that sentence, designed for or capable of operation, because these megawatts are going on to the utility system, and the utility system functions, I don't know if it's technically correct to say at AC or with AC, but you understand what I'm saying. Because it functions at AC, we believe that the design for or capable of operation implicitly is AC, and that's how ORS has interpreted it.
I understand that. And promise I'm not trying to go back in circles, but what I'm struggling with, if that is the interpretation in the case, if it were a utility in the same circumstances, would it be viewed the same by ORS or others that, well, the Siting Act doesn't apply because they've said they limit it to 74, even though it can do 80?
Sure. So again, without all of the factual intricacies, it's tough to make a commitment, but I can say that without a doubt, ORS strives to act in an even-handed manner, both with utilities, with solar developers, with any entity that comes before the commission or into which ORS conducts an investigation. It applies the rules that it has set forth in an even-handed manner. So without knowing all the factual intricacies, it's tough to make a commitment, but would we apply the same standard? Absolutely.
And I was not accusing you of that, all, Mr. Bateman. I totally believe that is the case. So thank you very much, and I have no more questions, Madam Chair.
Thank you, Commissioner.
Thank you, Commissioner. Any other commissioners with questions? Commissioner Powers? Are you okay?
Thank you, Madam Chair. Mr. Gressett,
Yes, sir.
still there?
Yes, sir.
Okay. I've just noticed while driving 26 that there is a project or a completed project located the area, not Orangeburg, but I kind of call it the Bowman area. Is that the one we're seeing that is the Orangeburg project and not the Orangeburg South project?
Neither one has been constructed yet. The Orangeburg County facility is about 3.5 miles southeast of the intersection of 26 and 301. About 4 or 5 miles south of Bowman.
Okay. Isn't there some solar project on 26 though, on the right coming from Charleston?
Yes, sir, I think so.
And do you know who that belongs to or the size of that project?
No, sir.
Okay. And I think you said that both of these are subsidiaries of the same company.
That is correct, sir. And that distinction of separate ownership results in separate interconnection agreements, separate filings with FERC, and all the above. They're all.
Wouldn't the result be, though, they're answering to the same shareholders or same owners?
Only in so much as a separate, distinct, wholly owned subsidiary would.
Okay, thank you. That's all I have.
Any other commissioner questions?
Madam Chair,
Commissioner Williams?
thank you very much.
Commissioner Williams, before we get your questions, could we take a short break? Council, if we could take a 10-minute break, we'll return at 3:45. Thank you.
Thank you, Madam Chair.
Good afternoon and welcome back to these oral arguments in docket 2021-114E. Let's take a roll call of commissioners. In the hearing room, we have Commissioner Powers, Commissioner Caston, Commissioner Thomas, Commissioner Williams, and Commissioner Belser. And joining us virtually, we have Commissioner Irvin. Do we have counsel back?
Counsel for the petitioners here.
And counsel for Dominion, yes, and counsel for ORS. Yes, thank you.
Yes, Madam Chair.
When we left off, Commissioner Williams had a question.
Thank you, Madam Chair. Attorney Gressett, thank you for the submittal of the maps. If we had a wider angle on me, you'd be able to see that my map is laying on my desk. The other thing that's on my desk is the letter that you all wrote on that we received on October 14th. And in it, you referenced 3 projects. And you also referenced 3 projects when you were talking to Commissioner Irvin. So my questions have a bigger picture perspective, but I want to understand where those 3 projects are, how they relate to the map that you submitted, for starters.
Certainly. There are 2 parcels of leased land. One of those parcels is owned by Orangeburg South LLC, and one's owned by Orangeburg County LLC. When the developers come in and they have parcels of land, it is customary to put in more than one application into the queue with the utility. In this instance, one of the parcels intersects with both Dominion lines and Santee Cooper lines. So there's an application pending with both of them. And then the other parcel has one pending with Santee Cooper. So what happens is the projects are placed into the queue, and depending on how they progress, what other business things happen, there are decisions made about whether Orangeburg South LLC will even proceed, or it may sell its interest to a totally, unrelated Smith LLC and just move on. Sometimes these projects are sold at various places along the process.
Okay, so I'm going to see if I'm going to take you another step farther and see if I followed you. Looking at your letter, which you wrote on October 14th, there's Orangeburg County Solar. There are 2 Orangeburg County solar projects. One's in the Dominion queue and one is in the Santee Cooper queue, but they're different megawatts. Are they the same land?
No, ma'am.
Okay.
There is, let me find my cheat sheet here. So the Orangeburg County megawatt calculation for AC is 73.98. And the one
I think that's Orangeburg South. Excuse me, Attorney Gressett.
Orangeburg South is 74.9.
Not.
And if you,
Take a look at your October 14th letter.
yes, ma'am.
Page 3 of 5 is what I'm looking at. It has 3 projects listed, and that particular one has Orangeburg South identified as 73.98 megawatts.
I am not sure which is the correct number for Orangeburg County solar project, because you are correct. We're showing one at 74.9 and another one is shown at 75.
So just to go back to my question and get to the big picture as opposed to the megawatts, are the 2 Orangeburg County solar projects that are in 2 different queues, are they the same project?
Yes, ma'am.
Okay. Thank you very much. That ends my questions.
Oh, thank you.
Thank you, Commissioner Williams. Commissioners, any other questions?
Madam Chair,
Commissioner Irvin?
Mr. Bateman, this question is for you. You still with us?
Yes, sir.
You recited some prior South Carolina Public Commission cases for a certain interpretation that authorized similar projects in the past. And you said you didn't have them in front of you, and I understand. But I'm wondering if you could pull those cases and send us a late filed exhibit, serve all parties, of course, and their attorneys, so that we'll have them in front of us. And we won't have to rely on your memory for the for the holdings. Could you find those cases and submit them within 10 days?
Sure. Well, I think I may be able to answer your question, Commissioner Urban. So let me know if this does. I did not recall the specific case which outlined the commission orders and their precedential effect. I don't recall that case citation.
Okay.
I do, however, have a number of dockets in which, from my understanding, the DC capacity of projects which were allowed to go through exceeds 75 megawatts. However, the AC capacity does not exceed that threshold. Now, whether or not those specific cases are similar to this instance, I can't speak to that, but I just as far as that one variable. Would you like me to read you off those dockets right now? Would that be helpful?
That would be helpful if you have them available. That way our commission staff attorneys can pull them and distribute them to the commission at the appropriate time.
Absolutely. Let me, looks like I've got a few dockets right here. I'll read these off to you. Now, again, I can't attest to the similarity, but I do think as far as the DC-AC issue, there may be something similar. Let's see, in no particular order, docket number 2017-185-E, docket number 2018-84-E, docket number 2016-100-E, docket number 2017-184-E, docket 2017-160-E, docket 2018-75-E, docket 2017-143-E, and docket 2017-188-E. Hopefully that is helpful, Mr. Commissioner, and I think that answers your question. Please let me know to the extent I did not.
It did, and thank you.
Madam Chair, this is Matt Gissendanner on behalf of Dominion Energy. Just for clarification, to make sure I'm clear, those dockets are not dockets in which a solar developer sought siting approval, correct? Those are just dockets where PPAs were filed?
Madam Chair, that's my understanding.
Okay, so those are not dockets where this issue has been considered.
Yeah, Madam Chair, again, I can't attest to the similarity of all of the variables which exist in this docket before the commission and those dockets. I do believe in those dockets the DC power output exceeded the 75 megawatt threshold, and the AC power output did not exceed the 75 megawatt threshold.
Okay, thank you. Commissioner Urban?
That's all the questions I have. Thank you, Madam Chair.
Thank you, Commissioner. Commissioners, any further questions?
Madam Chair.
Commissioner Williams?
Thank you very much. I have one final question, and perhaps it's to Mr. Bateman and Mr. Gressett. Mr. Gressett, in your March letter, you identify several other commissions that have made exceptions to the 125 kilovolt. And I wondered if there were any exceptions that existed within the South Carolina Public Service Commission records and dockets.
I'm sorry, within the South Carolina,
Public Service Commission dockets, whether,
I did not locate any.
okay. Mr. Bateman, are you aware of any?
Commissioner Williams, based on my understanding, so your question, I believe, is really two parts. Are there previous dockets in which an entity had some sort of line in its facility which exceeded the threshold of 125 kV? I do believe that we have a docket, and I can give you that docket number, where an entity had a line that was about 1,000 feet. And I don't know the specific KV of that line, so I do understand it to have exceeded 125. I can give you that docket number. The other question, or the other variable to the question, may be whether the commission can waive a statutory requirement, and that is certainly a determination that the commission will have to make. But to give you that docket number, Commissioner Williams, it is 2018-193-E. And again, same sort of disclaimer. I can't attest that the facts are similar to that from that docket to this docket. So I do understand that in that docket, some sort of line, I don't believe it was a Gentile line, but some sort of line associated with the facility exceeded the 125 kV threshold.
Thank you, Mr. Bateman. I appreciate that. Thank you for the docket number 2. No further questions.
Thank you, Commissioner Williams. Gentlemen, thank you for your arguments today. We appreciate your positions and appreciate your attention to the commissioner's questions. We will close this proceeding and it'll be taken under advisement. Thank you.